Tonight, the High Court has ruled that the Affordable Housing Act 2024 was enacted constitutionally, rendering the housing levy as constitutional. A three-judge bench led by presiding Judge Olga Sewe and Justices John Chigiti and Josephine Mongare dismissed prayers by 6 petitioners questioning the public participation exercise, the jurisdiction of the High Court to hear the matter, and whether the Housing Act was constitutional. The Kenya Revenue Authority has also been given the green light to continue to collect the tax. Here's Melita Oletenges with the details.
Questions raised by petitioners and rebutted by respondents on the constitutionalism of the housing levy were consolidated by a 3-judge bench. Their ruling dismantling the 6 petitions challenging the enactment of the Affordable Housing Act.
Petitions do not meet the threshold set out in Anarita. Thirdly, that the petitions lack precision as to which human rights have been infringed and do not indicate whether the said limitation is not that which is provided for under Article 24 and not qualified under 25.
We further note that the National Assembly that held consultations with various government agencies, including the State Department of Housing and the National Treasury and the State Law Office, offering opportunities for them to submit representations to the Joint Committee.
A hue and cry over the public participation exercise on the housing levy, which was prominently raised by Kenyans, was also dismissed.
Public participation was conducted in respect of the Public Finance Act, where the Affordable Housing Levy was originally introduced and anchored under Section 84 of the Finance Act.
The court noted that the National Assembly holds the authority to determine how taxes are calculated, imposed and collected, and that the Kenya Revenue Authority is mandated with the collection of taxes. The judges further ruled that the housing levy does not undermine devolution.
Are of the view that the Act does not offend the principle of devolution because the Affordable Housing Board under Section 16 has representation, both national and county government.
Further, they stated that whereas the 1.5% housing tax is different and seen as an extra burden on the taxpayer, it is not in any way discriminatory. The government will now be able to continue with the affordable housing levy deduction. Employers will also contribute a 1.5% deduction from their employees' salaries, bringing the total contribution to the government to 3%. Melita Oletenges, Citizen TV.